Imagine if the most popular rifle in America, the AR-15, and magazines were declared outside of the Second Amendment's protections. That's not just a hypothetical, that is now up for consideration in the Supreme Court. And the question before the court is a very simple question. Does the Second Amendment guarantee the right to possess AR-15s and magazines? So let's talk about the news that we got today in these cases and what this means for these challenges going forward. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also double check to make sure YouTube has not unsubscribed you. And also, I want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm is an amazing company. Their culture is unmatched. They're pro-freedom, pro-America, and they support the Second Amendment. So if you're trying to get healthier and you want great supplements, check them out using the link down below. And right now, if you use that link and you order a supplement, you can get a free 5-pack of protein sticks from 1st Phorm, and I can highly recommend them. They're amazing. So again, check them out using the link down below. As I mentioned in the intro, in this video, we're going to be discussing a critical rifle and magazine ban challenge that went in front of the Supreme Court to conference last Friday, and now we have some additional information on these cases. Now, the primary case that I want to talk about is Viramontes versus Cook County, and in that case, the petitioners are individual citizens along with organizations like Second Amendment Foundation, and they're challenging Cook County's ordinance, which makes it a crime to sell, transfer, or even possess so-called assault weapons. This case tries to also leverage some of the recent statements made by Justice Kavanaugh after the recent Snope rifle ban was denied by the Supreme Court last term. In that denial, Justice Kavanaugh made a statement that the time would come very soon where the Supreme Court would need to take up this rifle ban issue, and he indicated and he stated expressly that that would happen potentially in a term or two. Now, the plaintiffs in this case are pushing this challenge as the vehicle, as the case to fulfill that Supreme Court promise. And the Supreme Court held conference last Friday to consider both the rifle ban issue and the California magazine ban issue, which is in the case Duncan versus Bonta. Today, we got an update in both of these cases dealing with the rifle ban and the magazine bans. Both have been relisted for conference on December 12th. So really soon, once again, these will go to conference, and this could mean a few things for the future of these challenges. So let's talk about what is going on in these cases. Now, here's how this rifle ban essentially got to the Supreme Court. Back in 2021, the rifle ban lawsuit was filed in a federal district court in Chicago. Petitioners challenged the county's ban under the Second Amendment, and essentially in 2024, while the case was pending at the lower court level, Illinois passed a statewide assault weapon ban, also known as the Protection of Illinois Communities Act, as you know, it's known as PICA. We've talked about that case on the channel before, and in many ways it overlaps with what Cook County already did in their ordinance. Around the same time, the Seventh Circuit decided a case called Bevis versus Naperville, upholding Illinois' law and claiming that AR-15s were too militaristic to be protected arms. They ruled that firearms which are useful in military service could be outright banned and restricted. The district court, bound by what the Seventh Circuit already said in that Bevis case, then ruled and upheld Cook County's rifle ban, and the district court issued a summary judgment in favor of Cook County. In 2025, right after the Supreme Court denied review to the Snope case, the Seventh Circuit eventually affirmed that lower court ruling, and it leaned heavily on Bevis, treating AR-15s as essentially civilian versions of M16s, and therefore they said they're outside the Second Amendment's protections. Now the petitioners are asking for the United States Supreme Court to step in and resolve this conflict. They asked for the Supreme Court to declare once and for all whether Americans have the constitutional right to own AR-15s and similar semi-automatic rifles that states are just outright banning. Cook County recently responded by arguing that the court should once again deny review to the rifle ban case and simply punt this issue once again. Cook County argues that this case doesn't warrant the court's attention for multiple reasons. First, they say that there is no circuit split on the issue of rifles being protected arms. Second, they claim that this case is a poor vehicle for Supreme Court review since the plaintiffs in the county's eyes failed to follow some basic court procedures. They claim that they skipped discovery and offered no admissible evidence to support their claims. Essentially, in other words, the county is arguing that the plaintiffs here were in such a rush to get to the Supreme Court that they failed some of the basic procedures to have the type of evidence that the Supreme Court needs to review this case. Finally, Cook County contends that the lower courts were right on the merits of this issue. And in summary, essentially, they say that this case is procedurally defective, legally settled, and not the right vehicle for Supreme Court review and to have review of this type of critical issue. So at its core, this case asks for the Supreme Court to finally do what we have all been asking them for many years, which is to take up a state rifle ban, and then also in the Duncan case to take up the magazine ban question and ultimately strike those down. Now, both of these cases went to Supreme Court conference last Friday, so both the Vermontes rifle ban and the California Duncan case, which deals with magazine bans, both went to conference last Friday. You may remember that the Duncan case out of California was already granted, vacated, and remanded by the Supreme Court, in prior terms based on what happened in Bruen. But like other 2A cases, you had the lower courts, the Ninth Circuit, simply not properly apply Bruen, and that has led that Duncan magazine ban case to also once again end up in the Supreme Court. And today we got an update after that conference, and both the Vermontes and Duncan case have been relisted for another conference date, which is going to be December 12th. Now, you may wonder, why is the Supreme Court relisting a case so important for the outcome of what could happen in these challenges? Well, that's because all Supreme Court analytics and tracking on prior cases shows that a case has a higher odds of being granted review by the Supreme Court if it's relisted at least one time, but usually only once. So one relist is not detrimental to a case. Actually, in many ways, it's the best case scenario for these types of challenges. In fact, according to the Supreme Court data for the court's 2016 to 2020 terms, between 31% and 43% of petitions that were relisted only one time, at least one time, were eventually granted review. And between 66% and 75% of all cases granted cert were relisted at least once. So the fundamental truth is that a case relisted just once has a far better chance to be granted Supreme Court review. But also, I do want to note that all the data shows that multiple relists of a case, like what happened recently with the Snope rifle ban challenge out of Maryland, is actually a bad sign. And typically, that means that the case is going to be denied review. That means that the data shows that a case becomes less likely to be granted review if it's relisted twice, 3 times, 4 times, and essentially the more times that a case is relisted, the odds go down for that court, there to grant review to the challenge. Multiple relists often indicates that the case is going to be denied review, and that one or more of the justices is potentially writing some sort of dissent or statement on that case. So the cases being relisted once is not a bad thing. However, if we start to see these cases get multiple relists, 3 or more times, that is a strong indication that they will be denied, and that maybe at best one of the justices is going to write a statement in the case, maybe something like a dissent. To this point, the Supreme Court has avoided rifle and magazine bans like the plague. However, we will know very soon whether or not, Kavanaugh's statement and promise that they would take this type of issue in a term or two was actually true, or if it was just simply another empty promise. So that's what's currently going on in these critical rifle and magazine ban cases that went to conference last Friday. They have now been relisted. All hope is not yet lost. One relist is not a big deal. Sometimes it can actually be a strong indication. However, we're going to be keeping our eyes on the Supreme Court going forward for the order list, and we'll be keeping our eyes on them after the next upcoming conference, because if we start to see these cases get multiple relists, that is a bad sign for these challenges going forward. So that's what's currently going on. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of the 2 videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.